Jurors don't need to learn tort law. They're here to decide what happened and who's responsible. But most plaintiff lawyers spend the first 10 minutes of opening trying to be law professors, defining negligence, explaining burden of proof, walking through the elements of causation, and the more you explain legal terms, the more you make the case feel complicated, and confusion favors the defense. I'm going to show you why legal explanations are killing your openings, and the exact replacement language that keeps jurors locked in. I've been a trial attorney for over 20 years, and I can tell you the fastest way to lose a jury in opening isn't bad facts. It's a legal lecture. I've watched it happen. A lawyer with a great case stands up and says, "Ladies and gentlemen, the law of negligence requires the plaintiff to prove 4 elements: duty, breach, causation, and damages." And you can literally see jurors' eyes glaze over. One checks his watch, another starts dozing off immediately. The lawyer thinks they're being thorough, that they're being professional. Meanwhile, they're putting the jury to sleep. I'm going to show you why explaining the law feels safe, but is actually dangerous. How it quietly hands the defense ammunition, and the simple replacement framework that keeps jurors engaged and pointed towards a plaintiff's verdict. And I'll show you one line about the law that will be the only one you'll ever need to use. So why do smart lawyers turn into law professors in front of a jury? Well, there's 3 reasons, and all of them feel logical, which is why they're so hard to avoid. The first is fear of objection. You're worried if you come out too strong, the defense will jump up and say, "Argumentative." So you kind of retreat to the law. You define elements, lay legal foundation. It feels safe, like the judge will protect you if you stick to the legal standards. But here's the problem. The judge isn't your audience. The jury is. And the jury doesn't care about your legal foundation. They care about what happened. The second reason we do this is that law school gave us that habit. Define duty, define breach, explain causation, explain burden. It's how we were trained to think about cases. So it's how we talk about them. But law school teaches you to analyze cases, not present them. The third reason is this mistaken belief that jurors need legal definitions first. And this is a big one. Lawyers think if the jurors don't understand the legal standard, how can they apply it? But here's the fact no one wants to admit. Jurors don't apply legal standards the way lawyers think they do. Honestly, they're not listening to half the shit in the jury instructions. They decide based on stories, on right and wrong, what feels fair. Then they use the jury instructions to justify the decision they've already made. You don't need jurors to understand proximate cause. You need them to understand that one choice is why this injury happened. But here's the part that should really worry you. When you explain the law in opening, you're not just boring the jury. You're arming the defense. Every legal term you introduce gives the defense a word to hide behind. They love confusion created by legal terminology. If you say the defendant's action were the proximate cause of the plaintiff's injuries, defense will get up there and say, proximate cause is a complicated legal concept. There were a lot of contributing factors here. We have to look at this very carefully. It casts doubt in the jury's mind. You say we must prove our case by a preponderance of the evidence. The defense will say, preponderance? That sounds like a close call. You're going to have to weigh a lot of these different factors. You introduce the word and they just redefine it. My favorite one is where the plaintiff's lawyer says, the defendant's conduct fell below the reasonable standard of care. And the defense says, reasonable people can disagree. That's all we're saying. The word reasonable alone has probably cost plaintiff lawyers billions of dollars in verdicts over the years because it gives jurors permission to say, well, maybe it was reasonable. Maybe it was just a judgment call. Anyone can make that mistake. Maybe I would if I were in that situation. And the last thing you want to do is have a juror see themselves in the shoes of a defendant. When you use legal language, you invite debate about definitions. When you use human language, you invite decisions about responsibility, and that's the whole game. Let me show you some differences between the legal terms and kind of the corresponding human terms. The defendant was negligent. Compare that to, well, he didn't look before he pulled into the lane. Same fact, completely different impact. You don't have to explain negligence, just get to the point. You might say, the proximate cause of the plaintiff's injuries. Instead, say, the choice is why the crash happened. Instead of using pain and suffering damages, talk about what in the plaintiff's life has changed. One sounds like a textbook, the other sounds like part of a story. Which one do you think jurors will remember at 4 p.m. when they're deliberating and want to go home? Okay, but if you can't explain the law, what do you actually say? Well, you translate it for them. You take every legal concept and turn it into a common sense question that any juror can answer. Here's the framework. Instead of duty, breach, causation, and damages, you give the jurors 5 simple questions. I'm going to tell you them right now. Question 1, what is the safety rule here? Not a legal duty, a human rule. You look before you pull into an intersection. You fix the hazard you created. You don't text while you're driving. Rules that everyone already agrees with. Rules that don't need a law degree to understand. The second question, did the defendant break it, meaning the rule? Not breach of duty, not fell below the standard of care. Did they break the rule, yes or no? That's a question every juror can answer in 5 seconds. Third question, was it preventable? Not proximate cause, not but-for causation. Most lawyers I know can't define those terms clearly. Instead, you want to ask, if the defendant had followed the rule, does this happen? That's it. That's causation in one sentence in a way that a jury can answer it. Question 4, what did this choice change? Not the plaintiff sustained injuries, including not pain and suffering and the amount of. What can't they do anymore? What changed? What was taken from them? That's what jurors need to feel. Not a damages calculation, a human loss. And the last question, the 5th one, what verdict fixes what was taken? Not we're asking for compensatory and non-economic damages in the amount of, or here's how you calculate the damages. You ask them, what's the right thing to do here? What makes this right? 5 questions. Safety rule, violation, avoidability, harm, and fair repair. Every one of them maps to a legal element, but none of them sound like law. They sound like common sense. And that's the point. Let me show you what this looks like in a simple rear-end crash. Safety rule. You have to keep enough distance to stop. Violation. Defendant did not. Avoidability. If he had kept his distance, there's no crash. Harm. Sarah can't pick up her daughter without pain. Fair repair. We're asking for a verdict that accounts for what she lost and what she will keep on losing because of this. That's your whole liability and damages story. No legal jargon, no elements, no lecture. Just 5 questions that point jurors toward a verdict. And you can keep going back to that framework because you want the jury to remember it throughout the trial. Now, if you want more of these trial frameworks, then check out the link in the description below. But I know what you're thinking now. Don't I have to mention the law? The judge is going to instruct them. I need to at least set it up. Now, I'm probably going to get some flack for this from other lawyers, but you only need one line, really. Tell them, the judge will give you the law at the end of this trial. My job is to show you what happened and the evidence that shows it. That's it. 1 sentence. You've acknowledged the law exists. You've deferred to the judge, and you've told jurors exactly what your job is in this whole situation. Now get back to the story. Save your legal standards for motions, charge conferences, legal arguments outside the presence of the jury. And in closing, after the story is locked, after the evidence is in, after the jury already knows what happened and has seen the evidence through the lens that you gave them, then you can briefly connect the dots to the jury instructions. But even then, lead with the story, not the legal standards. The bottom line is, jurors don't reward legal accuracy. They reward clarity, story, and confidence. Now you know what to stop saying. But if you start your opening in the wrong place, you might lose the jury before you even get a chance to use any of these new techniques. So if you want to know where to start your opening, then you need to watch this video next.